Welcome to The Explainer. Okay, we're just going to dive straight right into this one. Today, we're decoding a really fascinating mechanism tucked inside the Indian judicial system. It's an absolutely crucial rule to prevent the total chaos of parallel lawsuits. Specifically, we're looking at Section 10 of the Civil Procedure Code of 1908. You'll often hear legal folks refer to this by its doctrine name, Res Sub Judice. So to understand why a rule like this even needs to exist, I want you to picture a scenario. Imagine the sheer confusion, the wasted time, and the drained resources if two completely different judges, sitting in two different courts, were actively trying to solve the exact same dispute at the exact same time. The biggest risk here? Well, they could easily arrive at totally opposite verdicts. One judge looks at the facts and says, you own the property, and the other looks at the same facts and says, nope, you don't. It would literally be a legal nightmare. To make this complex piece of code super easy to digest, we are going to run through 5 main areas. First, the parallel lawsuit problem. Second, the origins of res sub judice. Third, the essential conditions. Fourth, some landmark case laws. And lastly, a critical analysis. All right, Section 1, the parallel lawsuit problem. Let's look at exactly why we need Section 10. Let's say you've got Party A, and they file a lawsuit against Party B over a disputed piece of land, and they file this in the Delhi District Court. Now, Party B, maybe as a delay tactic or maybe just out of pure frustration, retaliates. They go and file another suit regarding that exact same piece of land, but over in the Mumbai High Court. Without some kind of intervention, both of those courts are going to waste valuable judicial energy on the exact same set of facts. This is exactly where Section 10 steps in. It's basically the ultimate pause button on that second trial in Mumbai, stopping those conflicting judgments before they even have a chance to happen. Moving right along to Section 2, origin of Res Sub Judice. Let's dig into its historical roots for a second. So let's break down that Latin, because it sounds more intimidating than it is. Res simply translates to subject or matter, and sub judice means under a judge's control or under consideration. Put it all together in plain English, and the term just describes a situation where a legal matter is currently active and pending trial before a competent court. Think of it like a giant "Do Not Disturb" work in progress sign hanging on the door of the legal system. Now, what's super interesting is that this doctrine isn't some modern invention. It actually originates directly from ancient Roman jurisprudence, and it's built on 2 incredibly logical philosophies. First, that it's in the state's absolute best interest to limit litigation. Basically, lawsuits have to stop somewhere if we want a functional society, right? And second, the principle that no one should be vexed or harassed twice for the exact same cause. Fundamentally, this is all about fairness to the people involved and efficiency for the state. Okay, Section 3, the essential conditions. Let's look at when Section 10 actually applies. For this rule to officially kick in, the courts require a really strict checklist to be met. First off, there have to be 2 distinct suits, an older one and a newer one. Second, the core matter and issue has to be directly and substantially the same in both of them. Third, it has to be between the exact same parties, litigating under the same title. And finally, that first suit must be actively pending in an Indian court that actually has the jurisdiction to grant the requested relief. If you check all 4 of those boxes, boom, the rule applies. Now, here's a crucial distinction that honestly trips up a lot of people. Section 10 is a pause button. It is not a stop sign. It prohibits a court from moving forward with the actual trial of that second suit. But, and this is a big but, it doesn't stop you from initially filing that second suit. And, more importantly, while the trial itself is frozen in place, the court is still totally allowed to pass interim, emergency orders. So things like temporary injunctions or maybe appointing a receiver to protect a property while everyone waits. That's all still fair game. Oh, and that brilliantly brings us to a key exception that's written right into the explanation of Section 10. If the previously instituted case is happening in a foreign court, let's say over in London or New York, Indian courts are absolutely not going to halt their proceedings. The doctrine of res sub judice is there specifically to protect the efficiency of the Indian judicial system, not the entire world's. All right, Section 4, landmark case laws. Let's see how the Supreme Court has actually handled this in the real world. Back in 1998, in the landmark Indian Bank versus Maharashtra State Cooperative Marketing Federation case, the Supreme Court firmly clarified the exact point we were just talking about. They ruled that courts can absolutely still pass interim orders to protect parties. It's the trial that gets paused, not the court's ability to prevent immediate, irreversible harm while things are on hold. Then you have the 2013 ruling in Aspijals, which is super important because it sets a really strict boundary on what the phrase substantially the same actually means.
The Supreme Court pointed out that you can't just hit the pause button on a second trial just because a tiny, insignificant fraction of the lawsuit overlaps with an older one. No, the entire core, substantial issue and dispute has to be identical. And this is huge because it prevents sneaky parties from abusing Section 103 just to delay justice on a minor technicality.
Also, keep in mind the 2005 National Institute of Mental Health case. This one determines something vital about the wording of Section 10. When the code uses the word court, it strictly means civil courts. So you can't invoke res sub judice to pause things if one of your cases is sitting in a completely different forum, like a specialized tribunal or a revenue court. The rule is strictly for managing concurrency between civil courts.
Let's bring it home with Section 5, critical analysis. Let's look at some of the paradoxes here. If you're ever scratching your head confused about whether Section 10 should apply to a situation, the 2003 Rada Davey case gave us the perfect litmus test. You just ask yourself one question. If the judge in the first court makes a final binding decision, would that decision completely and totally resolve the questions being asked in the second court? If the answer is yes, meaning the matter would become res judicata, or a fully decided matter, then that second court absolutely 100% must stay its proceedings. Now, here's a crucial takeaway, and it's kind of paradoxical if you think about it. Section 10 is a mandatory rule. Courts have to apply it, but it doesn't actually strip the second court of its inherent jurisdiction. What does that mean in practice? Well, if a judge accidentally ignores Section 10, goes ahead with a second trial, and actually passes a decree, that decree is not legally void. It's not a nullity. The system merely sees it as a procedural irregularity. And because it's technically just a rule of procedure, the parties involved can even choose to waive their right to it and just ask the court to proceed anyway. Crazy, right? As we wrap up this explainer, I want to leave you with something to chew on. When you consider the sheer vastness of the Indian legal system, with its millions of pending cases, Section 10 is obviously brilliant for preventing chaos and saving time. But ask yourself, how can we continue to refine this doctrine? How do we strike that perfect balance between strictly preventing duplicated efforts while ensuring we stay flexible enough that justice isn't unnecessarily delayed by clever lawyers abusing that pause button? It's a complex balancing act, and honestly, it's one the courts are still actively refining today. Thanks for joining me to decode all of this, and hey, keep questioning how our systems work.